Good morning and welcome to the BBA's fourth webinar on the new accountability regime delivered in partnership with law firm McFarlane's. In previous BBA webinars, we've covered the essential elements and the implications of the new regime, the impact of the new regime on foreign banks, and last month we covered the new conduct rules. All previous webinars are available on demand and free of charge via the BBA website. Today, to discuss senior managers regime, are you taking reasonable steps? I'm delighted to be joined this hour by Simon Hills, BBA Executive Director, Prudential Capital Risk and Regulatory Relationships, and David Berman, Partner at McFarlane, who just last month published the book Individual Accountability Under the New Senior Managers Regime, A Practical Guide. Just before I hand over to Simon, I'd like to invite you to participate in this webinar in two ways. Firstly, by asking questions, and secondly, by participating in the delegate polls. If you have a question for the panel, you can wait until the end, but given the number of attendees we have on this webinar, you can ask a question at any time simply by clicking on the orange Ask a Question button on the screen, which is located underneath the presentation. Please note that when you ask a question, your name and your organisation is not disclosed to other webinar attendees. Secondly, if you would like to also participate in our Ask the Audience polls, to participate in the polls, a pop-up box with the question will appear on your screen. Simply answer the question in the box and click OK. We intend to present for 40 minutes and then answer your questions for the remaining 20 minutes. Simon, over to you.
Thank you, Phil. As many of you on the line will know, my main work here at the BBA is in the area of prudential regulation. That means responding on behalf of members to the whole raft of changes that have been proposed by regulators in the wake of the global financial crisis. Changes that mean banks are holding more capital, more liquidity, doing more robust stress testing, doing recovery and resolution planning. And at the moment, of course, a couple of very important consultations out from the Basel Committee on the revised standardised approach to credit risk and revisions to the operational risk framework. All this is being done so that banks are less likely to fail in the future and become a burden on us as taxpayers. I'm sure we all support that. I came into this area, the senior managers regime work, because all those prudential regulations, all those changes were being implemented in the EU through CRD and CRR. And the Capital Requirements Directive has some high-level governance and diversity requirements in it. So when the Parliamentary Commission on Banking Standards came out with its recommendations on improving individual accountability, it fell to me to lead the BBA's response. And a very interesting couple of years it's been, I must say. And I do think that the introduction of the senior managers regime is equally, if not more important than those other more capital, more liquidity requirements. It really does have the potential to change behaviours in banks from top to bottom for the better. And without that, we won't have re-established in people's minds the idea that banks are trustworthy. And I see this as a continuing issue, although one that's very much moving in the right direction. So that's the upside, but let's not forget the downside, or potential downside, because in its business plan, the Financial Conduct Authority said the accountability of individuals in positions of responsibility needs to be improved and overall standards of governance raised. The senior managers regime will make it easier for both firms and regulators to hold individuals to account. As you know, the regulators have designated 18 different senior manager functions, role holders such as chief executives, heads of audit committees, CRO, CFO, and so on, which emphasises that the senior managers and certification regime targets essentially board and executive committee. And they've also designated some prescribed responsibilities which must be accepted by a senior manager, by a single senior manager. There's very little scope for sharing of responsibilities, and that senior manager will be held liable if something goes wrong on his or her watch. And as you know, many of you have been going through the grandfathering process on behalf of your colleagues, all senior managers have to be pre-approved by the FCA and the PRA. I've talked to a number of bosses, very senior people at member banks, who are almost invariably and unequivocally supportive of the new regime. They say it's given them the opportunity to refine job descriptions, it's provided greater clarity about who does what, it's enabled the board to make sure they've got the right people in the right roles, and it has reinforced the governance process. So all good outcomes. But there's still work to do. As you know, the senior managers regime came into effect at the beginning of the week. There will be ongoing challenges, though. How, for instance, do you build on existing HR data in your personnel systems and link it to regulatory requirements on a dynamic basis? How do you make sure if there is a potential breach, you can demonstrate to the supervisor you had the right references, you had a robust interview process, you gave the individual appropriate training, your performance appraisal system was able to identify individuals who are not fit and proper, and how any remedial action was followed through. How was onboarding of new colleagues managed, and how were handover processes documented. And remember that information has to be kept for a good number of years and may have to be available to individuals who've subsequently left the bank if they need to clear their name at a future date. So there are still, as I say, significant challenges to be overcome as the senior manager regime moves into business as usual. How do you have an audit trail, a single mineable source of evidence? How do you unlock all the info that a senior manager needs to ensure her or his devolved responsibilities are being carried out? And how will a senior manager, importantly, evidence that they've taken all reasonable steps to avoid a breach occurring? Now, the decision to review the presumption of responsibility, or the reverse burden of proof, at the back end of last year has, I think, been overblown. Yes, we were concerned that it would put people off becoming senior managers because it would have required the senior manager to demonstrate to the regulator that she or he took reasonable steps to prevent the breach occurring. Under the revised legislative requirement, and this is the first time the requirement to take reasonable steps has been expressed in primary legislation, previously it was in the handbook, regulators, rather than the senior manager, regulators will have to prove that the senior manager failed to take reasonable steps, that it is reasonable for a person in that position to have taken to prevent a regulatory breach from occurring. So that restores the presumption of innocence. But it does still make the senior manager responsible for bad things that happen on their watch, and I don't think any of us would think that was not entirely right and proper. So senior managers are at risk still, and I think that's right. We should manage our businesses, the businesses that we are responsible for, professionally, properly, prudently. But that still leaves the question of what do reasonable steps look like, and that's what David Berman from Macfarlane's, who leads the financial services practice at Macfarlane's, is going to discuss with us today. David, over to you.
Simon, thank you very much indeed. One of the most obvious questions that senior managers have been asking themselves is precisely how am I exposed under the new senior managers regime? I'm not proposing to go into a great legal treatise, but just to summarise, there are essentially three avenues of exposure for senior managers under the senior manager regime. They are not mutually exclusive. There's the duty of responsibility, which Simon's just alluded to. There's the knowingly concerned route and the breach of the conduct rules, as you will see on the slide before you. Now, as you will also see, each of those avenues points ultimately to the need for a senior manager to be able to evidence that they took reasonable steps. In other words, the key question being, what more could I reasonably have been expected to do in the circumstances? Or put another way, what could I reasonably be criticised for having not done in the circumstances? So in a sense, it doesn't really matter which of the three routes the regulator might pursue a senior manager under. In essence, the senior manager, irrespective of the route of enforcement, is going to need to get to the same place. And of course, what nobody can stop, and no senior manager can stop, is the regulatory spotlight one day falling upon them, in the same way that you can't stop somebody from suing you. They might not have a leg to stand on, but at the end of the day, you cannot control necessarily whether or not you will one day become the subject of adverse regulatory scrutiny. And I suppose the mindset that I would advocate senior managers get themselves into is to think, okay, so heaven forbid, one day I find myself under that regulatory spotlight. What is my story? In other words, what are my reasonable steps? And crucially, how am I going to demonstrate that I actually did take those reasonable steps? Words alone are unlikely to suffice. Now, the slide pack that will be made available to you after the webinar contains a whole host of different practical pointers. One of the sensible ways that I certainly think senior managers might approach their exposure under the senior managers regime is to ask themselves some deliberately provocative questions. And I think that there's arguably no better way of focusing one's mind, and provided that you answer the questions honestly. What we've done on the next slide is just to give a sense of some of the questions which senior managers might usefully pose to themselves. Now, this list is clearly not an exhaustive list, but it's been drawn based on various recent enforcement notices, regulatory pronouncements, our own insight and experience of advising clients through regulatory interrogations. And I think any senior manager could do a lot worse than actually work through that list and answer those questions quite honestly and frankly. And if there are known weaknesses in any of those pointers, then it would be advisable for a senior manager to do something about that, rather than just brush it under the carpet and hope that said issue never actually materialises in practice. So just to take a couple of examples, do I have a sufficiently strong grasp of the risk management framework, in particular its design, operational effectiveness, and any specific weaknesses? Now, the regulator's been very clear. It doesn't necessarily expect a senior manager to be able to talk to the minutiae and the nuts and bolts of a risk management framework. But what the regulator absolutely would expect any senior manager to be able to do is to articulate at a relatively high level what that risk control framework is within their particular area of responsibility. Do I assess the ongoing suitability of individuals working within my business area? How do I actually do that? The regulator asked me that question. They asked me to demonstrate how I do that on a day-to-day basis. What am I pointing to in response? Do I have a sufficiently strong grasp of the governance framework? You might think that's a relatively elementary question, but I wonder how many senior managers could confidently articulate the governance framework, particularly within their area of responsibility. Am I comfortable that I receive an appropriate level of management information, or MI, to enable me properly to discharge my responsibilities? MI is obviously clearly incredibly important. In order for a senior manager to have the requisite level of visibility over their area of responsibility, MI, management information, is one very obvious and important way in which senior managers are expected to keep abreast of what's actually going on the ground within their areas of responsibility. Ignorance will be no defence. What sort of oversight am I exerting over my delegates, over my direct reports? How can I demonstrate that oversight? We've got a slide within the pack, which I will get onto the screen in a second, which looks in a little bit more detail at some practical guidance around delegation and oversight. And of course, one of the changes to the conduct rules under the SMR is that there is now a specific conduct rule relating to delegation. Senior manager must delegate appropriately and oversee any delegates effectively. And if I was a betting man, I wouldn't be at all surprised if in due course one or more senior managers weren't taken to task for a perceived failure to oversee a delegate or delegates effectively.
And of course we remember, don't we, David, on a number of occasions that the PRA and the FCA have said this is not going to be an enforcement-led regime, and I'm sure that's right for the first year or so, maybe. But I mean, your sense and mine, I think, is that the issues that will be raised will be around the systems and controls, the oversight, rather than specific instances, I suspect.
I suspect that's right. And what's been interesting is that in advising a number of banks in their preparations for the senior manager regime, what's become apparent is that there is something of a myth out there, which is that, well, my reasonable steps are always going to be evidenced via some formal minutes. Okay? Well, that may or may not be right, but I'm not convinced that will necessarily get you home and dry. And you could look at delegation as a good example of that. So if something happens within a senior manager's area of responsibility and it relates to one of their delegates, quite quickly, if the regulator became aware of the incident, the spotlight could be pointing back up to the senior manager, the regulator alleging that the senior manager could not have effectively overseen the delegate, because if he or she had have done, then the incident would not have occurred in the first place. Now, if they go down that route, of course, the senior manager concerned is very much on the back foot. They are going to have to be able to demonstrate that they did indeed take reasonable steps to oversee that delegate. Well, what are they pointing to? I suspect that in that sort of a scenario, formal minutes of a meeting, of a board meeting or an ExCo meeting or a product development committee meeting, whatever it might be, are not going to contain the answer for that particular senior manager. Where the answer is much more likely to be contained is perhaps in an email that follows up that demonstrates that the senior manager and his or her direct reports were meeting periodically, that the senior manager was periodically checking in on the activities of the direct report, in headline terms covering some of the issues that they discussed, some of the action points resulting from their meetings, etc. So there's a record to point to. And there may be some people out there thinking, oh, this is all, this is just documentation, it's work creation, it's another unnecessary level of bureaucracy. Well, I choose to view it slightly differently, and I think there's an argument to say that actually, if we keep focusing on this delegation example for a second, that actually that's no bad thing to ensure that there's actually a demonstrable audit trail, for want of a better phrase, when you are exerting oversight over your direct report. So in other words, if you have weekly meetings or monthly meetings, why is it such a bad thing to follow up those meetings, for example, with an email to the direct report saying, we discussed X, Y, and Z at a high level, these were the action points that we agreed, we're going to follow up next time with A, B, and C, there we go. That doesn't necessarily call for a verbatim treatise of every last word that was discussed at that meeting. Of course it doesn't, and of course that's not realistic. But something, and a lot of people would say, actually, that should be good practice anyway. We should be doing that.
Do you think that some of your more cautious clients are setting up the office of the chief executive or the office of this chief financial officer in order to provide a protective shell around them? Groups of people who will, on their behalf, be following up to make sure that the delegated responsibilities they have allocated to other individuals are set up. So an increased cadre of people supporting the CFO in that.
I think that may well be right, and there will be some people who take the view actually that's good practice. That's arguably what should have been happening in any event. I suspect that in many cases it probably was happening in any event. What was perhaps lacking was a degree of formality and robustness around it. So in other words, whilst these things might have been happening, they might not have been recorded systematically or methodically.
Bearing in mind that the FCA and the PRA's default setting is if it's not been documented, you haven't done it.
Indeed. I mean, that appears to be the sort of general working presumption. It's not necessarily a particularly fair working presumption, but it is what it is, and industry is on notice that unless you can point to some hard contemporaneous evidence that something did indeed happen, you are likely to struggle to convince the regulator that it did in fact happen. So I'm afraid possibly one of the key practical changes that this senior managers regime might drive is a focus more on being a little bit more methodical about what records are kept and of what. Now that's easier said than done. Clearly a balance needs to be struck. It's probably the most common question that I've been asked in advising on the senior managers regime is how far are we expected to go to document things in order to be able to demonstrate, if need be, that I did indeed take the requisite reasonable steps. Now,
we've got a question that is sort of alluding to that. How far down the organisation does this drilling down of oversight go? I don't think we've got a clear view yet. I think we'll have to wait and see what enforcement actions indicate in terms of
I think that's right.
How many down do you go?
Yeah. I mean, what is clearly critical from any senior manager's perspective is that they feel, in all honesty, that they have got sufficient visibility of what is going on underneath them within their areas of responsibility. Now, that doesn't mean that they have to know every last detail of every operational practice that's going on. Of course, that's not realistic. But there needs to be something of a cascade upwards, so that what information is reaching them is the key important information. Clearly, it's in nobody's interest for them to be deluged with far too much irrelevant and inconsequential management information or reports, for example. And we've seen firms criticised for just that. Okay, so again, clearly there is a balance to be struck here. I suspect that some organisations are still feeling their way a little bit as to where that balance lies. I don't think there's a silver bullet, necessarily right answer. Practicality dictates that we can't go documenting everything. That's just not realistic, nor do I believe it's what the regulator expects of us. But we need to be able to document enough key decisions, key challenges, key debates. Now, as to what is key, that of course will depend on the particular circumstances, the individual, their role, etc. And I suspect that more often than not, you as a senior manager, you'll sort of know what's key. You might apply a rather unscientific rule of thumb. Is this a sort of decision or a sort of discussion that could possibly come back to bite me? Okay? And I think, certainly speaking as a lawyer, you tend to know what those scenarios are. You tend to have a pretty good sense as to what the really high-stakes issues are. And just to go back to what I said earlier, to dispel the myth that the answer will not necessarily lie solely in the minutes for the senior manager. The minutes, please don't misunderstand, the minutes are clearly incredibly important, and senior managers participating in committees and boards should absolutely be confident and comfortable that the minutes are a fair and proper reflection of the debate and discussion, and that they're sufficiently balanced, etc. That's a given, that goes without saying. But from a reasonable steps perspective, I suspect that in many cases, a reasonable steps defence is not likely to be found in the minutes. It may well be found outside of minutes, because by the time that an issue finds its way up the governance chain into minutes, it's arguably too late by then.
Okay. And how confident do you feel that senior managers have the systems and the processes in place to be confident?
Yeah, I mean, there is a school of thought that says actually a senior manager who was a SIF under the previous approved persons regime, if they were doing what they should have been doing under the prior regime, then actually they should be pretty well placed under the SMR. And I have some sympathy with that. I think that's largely true. I think what we might see is not necessarily radical overhaul of day-to-day practices, because if we're seeing that, then I'd question the quality of the practices that went before. More, I think, a finessing, perhaps a slight adjustment, perhaps a slightly different mindset. Okay, so the need to be able to show reasonable steps today was what it always used to be, even under the approved persons regime. Again, what it boiled down to ultimately for a SIF was the need to be able to show reasonable steps if you are ever challenged. And therefore, it's more of a sort of mental adjustment, I think, if anything else. And as I said earlier, I think one quite healthy and constructive way that senior managers might approach this whole topic. I mean, we all wish that there was a definitive list of measures that you should take that would definitively constitute reasonable steps. Of course, that's not realistic, but I think the best you can do as a senior manager is to try and get yourself into the right mindset, i.e. understanding fundamentally where is the regulator coming from? What sorts of conduct and activities are likely to aggravate the regulator? And there are some clues. There are clues in the COCON handbook of the regulator which puts a little bit of flesh on the bone in terms of the sorts of practices that the regulator would regard as falling foul of some of the conduct rules and the senior manager conduct rules. And that gives you, to my mind, a reasonable flavour of where the regulator is coming from. A lot of that guidance frankly, you might say is mere common sense. The fact that you should not, for example, be delegating an issue to your compliance function if you know and you are on notice that compliance function is already stretched to the limit. In other words, how on earth do you expect the compliance function to discharge their delegated tasks properly and on a timely basis if you know that they're already overstretched as it is? That's essentially common sense. So I do think we will see a degree more formalisation from senior managers. So again, just to stick with the delegation example, I think we will see senior managers becoming a little bit more methodical about the way in which they document their key decisions and their day-to-day oversight.
So we've got a number of questions coming in as well. We had a plan, but certainly addressing the questions is just as important as the slide deck.
So there's a question here about regulatory reporting in the context of the senior manager being confident that the numbers for capital and liquidity are being reported correctly to the regulator. I think this is probably where internal audit comes in.
Oh, I think it is. I mean, I think clearly not every senior manager is expected to know all of the technical nuts and bolts of how a big banking institution actually operates. That's clear. However, I think there is certainly an expectation that senior managers are at the very least asking the right sorts of questions. So let's say, for example, there's a board meeting and a rather technical reporting or liquidity issue or capital issue is being discussed. That might not be in the comfort zone of many of the senior managers sitting around the table, but I think what they would be expected to do is at least ask and probe around, okay, so this report that's just been presented to us, what were the feeds into it? Who inputted into it? Just to get yourself comfortable that as best you can, that the right functions and the right individuals had fed into that report, that the right challenges had been levied. And if you're not satisfied with the responses, then you'd be perfectly entitled / expected to challenge and say, well, actually, I'm not satisfied with that.
And indeed, in extremis, I remember the PRA's supervisory statement on the collective responsibility of the board did say that the expectation was that non-executive directors in particular should have access to a fund which allows them to take outside advice where they really feel it's necessary.
Sure, and just on the very topical theme of collective responsibility, another frequently asked question in the context of the SMR is to what extent does the doctrine of the notion of collective responsibility sit alongside the SMR, which clearly is very focused on individual accountability, and how do the two concepts actually reconcile with one another? And the PRA put out a statement in one of its policy statements, and essentially the thrust of it was that they see the doctrine of collective responsibility as sitting alongside and being complementary to the notion of individual accountability. So in other words, if you are a participant at a board meeting, for example, and a decision is taken, then you will be collectively responsible along with...
And I think it's important to remember that means a board member, whether you're an executive or a non-executive.
Indeed.
And I think that distinction perhaps is not so clear in people's minds.
I think that's absolutely right. And in the same context, and we do have a slide on this later, and perhaps I can just turn to it now whilst we're on the topic. A related question that often comes up is how directors of banks and other regulated firms can reconcile their statutory duties as directors, which in broad terms, under the Companies Act, which in broad terms is all about doing the right thing by shareholders, acting in the best interest of shareholders, with their regulatory responsibilities, which in very broad terms are doing the right thing by customers, clients, and the wider market. And of course, those two interest groups, those of shareholders and those of customers and the wider market, are often, in practice, not going to be aligned. So how does a director reconcile those particular tensions? And it's a very real question. It's not new, by the way. I mean, it's not new just under the SMR. This tension has always existed. And I think the answer really lies in the approach that most directors and boards take to this issue, is that in practice, the interests of clients and the wider market will typically end up prevailing. The thinking behind that is, if we do the right thing by our clients and the wider market and therefore keep the regulators happy, the profits in theory should follow, shareholders should in theory be happy. Conversely, if we don't do the right thing by customers and the wider market and the regulator ends up throwing the book at us, the consequences, the financial consequences of that alone
could be
so catastrophic that they would be almost inevitably very damaging to shareholder value. And that's in practice the way in which that tension will often get reconciled. I certainly sense that where the regulator is coming from on this topic is that it would expect the interests of customers and clients to be prioritised ahead of the interests of any other user group. And in fact, I go so far as to say that any sense that was given to the regulator by a bank or another regulated firm that the interests of clients in the wider market was in some way being subordinated to those of the firm's own selfish commercial interests or those of its shareholders, I think would be a very, very dangerous message to be sending to the regulator.
I do hope we've all got that message over the years. Treating customers fairly is paramount, and as you say, from that flows the reasonable profits to the shareholders. We had a little bit of a touch on enforcement earlier on. Do you see, as you engage with your clients, some sort of flavours of the senior managers regime coming through already into some of the discussions you've been having? So we've known what the senior managers regime is going to look like in broad outline for a couple of years, and we've had the final rules since the summer. Do you sense that they have already started to permeate enforcement actions against individuals? It may be that all your clients are so good they don't...
I'm sure that's right. But in all seriousness, I mean, I think we won't know that for some time. I mean, of course, enforcement actions take many months to find their way through the system. I have no doubt that the regulator will feel almost duty-bound to be able to show some spoils of the new regime in due course. And they may well have a number of cases from which they could choose. We are unlikely to see that this year, just such as the enforcement process. But certainly I wouldn't be at all surprised, for example, if it's not too long before the regulators come in and visit some of the firms post-implementation to see how the SMR has been embedded, how well understood is it within the institutions. And on that note, we've also included in the slide pack some deliberately provocative mock interview questions, which again, senior managers might most usefully address and pose to themselves to see how comfortable they would be in answering these questions. How convincingly could you as a senior manager answer any of the questions on this slide and the following two slides? These questions essentially presuppose that the regulator's coming in, it's doing a post-implementation visit, and it wants to get a real feel for how well embedded the SMR really is. A real feel for how well understood is the regime by the senior managers. And we've set out here what you might think are some fairly elementary questions. How many certified staff and conduct employees do you have within your area of responsibility? And I suspect the regulator would expect a senior manager to have the answer at the tip of their tongue. And not to be scrambling around for that sort of answer. So, again, the approach that we've taken here is let's ask some deliberately provocative questions as a good test, a good benchmark for how well a senior manager really does understand the regime. And if a senior manager is working through these series of questions, I'll move on to the subsequent slides as well, and they are feeling distinctly uncomfortable, or rather they're thinking, my goodness me, I hope the regulator doesn't come in to visit us, because if they do and they ask me these sorts of questions, I'm going to be really struggling, then perhaps some more education it will be called for.
Yeah. I had an interesting discussion with somebody from the PRA talking about their particular work programme, and this was in the context, I think, of foreign banks, actually, and asking her, which may give you a clue about who it was, about how they were going to look at the senior managers regime implementation over the balance of the year. And she was toying with the idea of, well, let's take an incident of something bad that's happened or less optimum that's happened within a firm over the past 2 or 3 years, and then replay that. So do some sort of role playing in the context of, well, now we've got the senior managers regime. How would that have changed the outcome?
I mean, I think that's a very neat and smart approach, in my view, to actually, again, test it, honestly testing yourself. Back testing. I want to come back to that, if I may, in the context of culture and the approach to culture. I think it's also just worth considering. Lots of focus on what good might look like, what might my reasonable steps look like. But let's not also forget that the regulator's given us some quite stark clues as to what bad might look like. And I'm just going to move on to that particular slide. Sorry, forgive me. Let me just find it now. What does bad look like? Well, you can find some pretty good examples of what bad looks like just by referring to some recent enforcement cases, for example. The slide here is essentially a bullet summary of the key findings and criticisms against the so-called Co-op 2, whom the PRA has recently enforced against. Now, clearly, this is not an exhaustive list as to what bad looks like. But again, it gives you a flavour for the sorts of issues that the regulator had with these two individuals in this particular case. On the theme of enforcement notices, I think another practice which I know the regulator absolutely expects all regulated firms to undertake is that whenever a final notice or any form of other thematic report or regulatory pronouncement comes out, firms are expected to have digested and applied their minds to those final notices or pronouncements, and to have considered to what extent, if at all, those issues could actually take place within their own organisation. Even if the findings, it was a final notice aimed at a company in a completely different sector. What sort of read across might there be? And it's interesting because in some recent enforcement cases, we've actually seen some cross-references back by the regulator to prior enforcement notices, where the allegation has been, you were on notice that this sort of behaviour was problematic to us.
Yeah, and that crosses over into a question that's just come in, David, in relation to the extent to which the PRA and FCA documentation on the senior manager regime, which we've all been poring over for the past couple of years, is best practice. And I think the answer is yes, it's partly best practice, but you've absolutely got to understand the implications of enforcement and the sorts of
I think you have. I mean, a common gripe across the industry is the so-called regulation through the back door. So, for example, the regulator will publish from time to time some thematic reports outlining some good and poor practice observations. And the issue that some people have is that that's essentially regulation via the back door. It's not technically rule or regulation, but what it is a very clear articulation by the regulator of what it considers to be good and poor practice in a particular area. Now, the relevance here to SMR, to my mind, is very clear. If you are a senior manager and you have fallen, unfortunately, under the regulatory spotlight, and you are being taken to task, you're obviously going to want to try and establish your reasonable steps defence. What might be reasonable? If, for example, the regulator has published a relevant, related thematic report recently, where it has outlined some good practice, and actually what you did was an example of an observed bad practice, I think it would be quite tempting, in fact likely, that the regulator will point to that and say, well, hang on a minute, you were on notice of what we considered to be reasonable in the circumstances, yeah? And therefore we don't consider the steps that you took were reasonable. Our view of reasonable steps, you ought to have been able to glean from the statements that we made in that thematic report, for example. So I think the upshot of all of that is that it is incredibly important that all forms of regulatory pronouncement, whether it's final notices, whether it's thematic reports, even the speeches, are taken on board and considered, and the question asked, to what extent could these points be relevant to our organisation? And have we now been put on notice of certain issues that we might perhaps need to remedy within our own institution.
There's a slightly tangential question has come in here around enabling a person who is no longer with the bank. Maybe they've moved on for entirely reasonable reasons to another bank, and then they come under the spotlight in the context of the previous organisation. How have you found senior managers that you've been advising, to the extent you've been advising individuals seeking to have continued access to all the sort of email traffic that they think they would need to clear their name?
We're seeing slightly different practices on that front. It's clearly a very important practical question. In general terms, I think the approach that institutions are taking is that they will try and be as helpful as possible within reason. And they're hoping that gives the senior managers concerned an appropriate level of assurance that should they need to come back and retrieve certain information, that will be made available to them in due course, absent some very compelling reason otherwise. I think that tends to be the approach that banks are taking, which is we will be helpful where we possibly can be helpful.
Yeah, and I think this then goes on to how is the former senior manager going to pay for all this? Perhaps they've been a senior manager, they've retired, they've been a non-executive director.
Which is brought into focus the question of, are we covered with our D&O, and how's all that going to work? And again, different firms will have slightly different approaches. But I think for some firms have taken the view actually that there has been no need to change our existing arrangements.
Yeah, I guess you would want to make sure that was the case, because it's not cheap, even if you outsource the trawling through of 250,000 emails to India or Africa.
Sure. I mean, just on a related point, an issue that's come up, and no doubt will continue to come up, is the heightened potential for there being quicker conflicts of interest between the individual and the institution. So, of course, under the duty of responsibility, it's only where a regulatory contravention by the firm has occurred that duty comes into play in the first place.
In the context of the individual.
In the context of the individual.
So there has to be a failure by the firm, which is found, and then the regulator can take the decision to either go on or not.
Now you can easily conceive of the situation whereby it is questionable whether there has in fact been a regulatory contravention by the firm in the first place.
But the firm wants to move on.
The firm wants to move on. It's not a battle that the firm wants to fight. It's fighting a number of different fires at the same time. So its inclination is to hold its hands up and concede that there has been a breach. The senior manager, on the other hand, will be likely loath for his or her firm to take that approach, because as soon as the firm does, the senior manager is then potentially very much on the back foot and under the spotlight. So, that potential for conflict existed under the approved person regime. I think it just brings it into focus more under the SMR, and I think the potential for conflict arising earlier, the potential for a disalignment of interests arising earlier, really is there under the senior manager's regime.
Yeah.
I mentioned, Simon, do we have another question? Or? Yeah. I mentioned earlier that, Simon, you mentioned revisiting. Actually, how would we act in the same way today under the SMR as we perhaps did a year ago under the approved persons regime? And just on that sort of theme, the whole topic of culture, I mean, we could have a separate webinar just purely on culture. But
there's a follow-up for you, Bill. Thank you.
But joking aside, it's clearly a very important linkage to the senior manager regime, because, and indeed two of the prescribed responsibilities specifically relate to culture. A question, funnily enough, has just come in: how do we measure a firm's culture, and what type of reporting will be required? Well, there's no right or wrong answer to that. What we've sought to do in the slide pack, and I am just going to turn to the relevant slide now, is to just offer a few thoughts around the topic of culture. Clearly, culture has been a very, very important topic for the regulator over recent years. That remains the case today. I think what's more interesting, though, is that over the last year or so, we've seen culture specifically flowing into enforcement actions, both against firms and individuals. Now, it's incontrovertible that the regulator ultimately holds senior management responsible for instilling the right culture within their organisation. I think that's pretty hard for anybody to credibly dispute. The problem is this, and we've referred in the third box along to the David Kaplan final notice around about a year ago. And this is a quote from the regulator's press release accompanying the final notice. This case should serve as a warning to everyone that holds a significant function, so a senior manager in essence, that if a firm's misconduct is attributable to cultural failings, then we expect senior management to answer for this. Now, if we just pause on that for a second, you consider the relative ease with which the regulator can turn round and attribute any form of misconduct or any serious issue to a flawed culture. In other words, if your culture was as it should have been, this would simply not have been allowed to have happened. That immediately puts senior management on the back foot. So what's their story? What are their reasonable steps? How are they going to demonstrate to the regulator that they do indeed take culture incredibly seriously? Now, there's no silver bullet right answer to that, but on the next slide, what we've done is we've highlighted an approach which we know a number of institutions are taking to the inherently nebulous subject of culture. How do we get a grip and handle around culture? One way in which we know institutions are approaching this is by identifying some sensible cultural indicators. Indicators that we know the regulator uses. Okay, we've set out a list of 15 there. I don't think there should be any particular surprises. That's clearly not an exhaustive list, but it gives you a flavour of the sorts of things that the regulator might have regard to. So, for example, responsiveness to compliance issues, just to pick one example. Almost of equivalent interest to the regulator as to the nature of an issue itself is the manner in which that issue is responded to and dealt with by the firm. That in and of itself can often be incredibly telling and shine a real light on the true culture within an organisation. So what we're seeing certain institutions doing is selecting some sensible cultural indicators as appropriate for their particular businesses, accompanying those indicators with some stated cultural expectations. Okay, so in respect of each of these indicators, what are our expectations? How would we expect our firm to respond to a serious compliance issue, for example? Right? And then periodically, let's say it's annually, conducting a look back and saying, okay, so we might have had, for example, 3 notifiable issues during the course of the last year. Let's conduct a bit of a post-mortem. How did we actually respond to them? Was our response actually consistent and aligned with our stated cultural expectations? If not, why not? And I do suspect, if the truth be known, that up until relatively recently, if you'd have wheeled out the majority of bank and financial institution CEOs in front of, for example, the Treasury Select Committee, and they were asked what I think is a fairly obvious question. Well, okay, so you're all saying the right things around culture. You've got your value statements and all of that good stuff. But how are you actually periodically testing that you're doing and behaving in line with what you say you're doing? How are you testing it? And I think that's incredibly important for an organisation to be in a position to have something credible to point to say, no, we don't just pay lip service to culture, but we actually test ourselves on it. And we're not perfect, so we will have issues that crop up, but we will deal with them credibly and we'll respond to them sensibly, trying to learn lessons where lessons need to be learned.
10 minutes left for those on the webinar. If you do have your questions, please keep them coming through, and it's been a very engaging and very fast 50 minutes indeed. So yeah, please keep them coming.
I mean, the truth of the matter is, Philip and I, we're merely scratching the surface here. We're necessarily having to talk at a high level. We haven't got that much time. I think perhaps practices may well evolve over time. The regulator may issue some further pronouncements in terms of where its specific expectations lie. I certainly think that for the time being, at least, the so-called bedding down period, it really is as well that senior managers, if they don't feel that they've had sufficient training, then they should certainly request that training from their institutions. I'm hoping that not many senior managers fall into that particular category. But clearly awareness is key. Ignorance is no defence. I still suspect that there are some, albeit the minority, who take a rather cynical view to all of this and think, well, actually, as long as I run my business properly, I'm going to be fine. Well, perhaps on one view, yes, but I'm not sure it's quite as simple and straightforward as that. This is not a case of having to stifle what you're doing, or it shouldn't be a case of stifling what you're doing and what you're expected to do, what you're paid to do. Okay, as I said earlier, I think it's more a slight adjustments, if anything else, rather than radical overhaul. A slight change of mindset. Okay, so let's assume the worst. Let's assume that one day I do find myself under the spotlight. What are my reasonable steps? When I ask the question, well, what more could I reasonably have been expected to do in the circumstances? That's where you want to get to. It's a little bit like when you were at school, sitting exams. You always wanted to come out with that feeling, well, I gave it my best. What more could I have done in the circumstances? And provided that you can get to that stage, you should be as well placed as you possibly can be to resist any regulatory challenge.
We've not yet talked about, we've focused very much at the top layer, the senior management layer. We've not spoken so much about the certified layer, but of course there is the conduct rules that are coming into play next year.
Yes.
Do they provide an opportunity to reinforce culture within a business? Do you think? Have you had conversations with your clients about that?
Yeah, I think that's absolutely right. I think they do. And of course, there is an obligation on the banks to ensure that not only are all staff affected by the conduct rules aware of those rules, but that they also must take reasonable steps to ensure that they understand those rules. And that's inevitably going to involve some tailored training. And via that training, absolutely, some of those cultural messages, that's a great opportunity, to my mind, for them to be reinforced.
Yeah. Do we think, in your experience, David, I'm sure you've dealt with mainly the FCA, because I think that's probably where most of these actions are going to come from, but the PRA as well. Do we think the PRA is going to take a different view from the FCA?
Well, I'm not convinced. I mean, you only need to look at the very recent co-op case that was brought by the PRA. It related to individuals' conduct, but conduct as it pertained to prudential issues. Do I see the PRA taking a fundamentally different approach? No, I don't. They've clearly got different statutory objectives to the FCA. But of course, any form of conduct that is perceived as potentially impacting upon prudential requirements and obligations, it should be presumed is of potential interest to the PRA. And as we've seen very recently, the PRA is not afraid to bring enforcement actions against individuals for perceived conduct breaches when they pertain to prudential issues.
No, I think that's right. So a question here about really a horses for courses question. Reasonable steps, developments. Are there significant areas of discrepancy? I guess it's to do with a particular firm's risk appetite in this.
I think it is, and different institutions will have slightly different bees in their bonnet and focus on particular issues, perhaps more than others. Have we observed any fundamental differences in approach? No. Have we seen nuances in approach? Yes, of course we have, and that's to be expected, I suppose. But I think as a general matter, what we're seeing is a heightened focus on the need for demonstrability. That's how I would, I suppose, best sum up the key change really under SMR.
So, wrapping this all together, David, and also Simon, what are the next steps on reasonable steps that firms need to be taking?
I think the next steps are obviously to keep abreast of any regulatory pronouncements that come out, any more clues as to what the regulator might regard as reasonable, i.e. good and poor practice observations and the like, and that's clearly very important because, as I said earlier, industry is very much treated as being on notice of all of those pronouncements and expected to have applied their minds to them. I suspect some firms may well have a bit of a stock take 6 months into the regime. I think the BBA is also proposing to hold a sort of 6 months on type session. But maybe that's not such a bad idea, and maybe sitting down with the senior managers and saying, how's it been for you? Do we need to learn some lessons from the early months? what's working well, what's working not so well, and maybe taking some, stock, as perhaps they might be expected to do.
Yeah, and particularly in the case of non-executive directors, just to flag up, the BVA is looking to put together by the end of the year a sort of bank non-executives club, which will provide a forum, both virtual and real, for exchanging views on all aspects of the NED's role within a financial institution. I'm sure the issue of the senior manager regime, as you say, 6 months on, will be an important topic they want to chew over with us.
Okay. Two dates for your diary. 5th of May, Getting Culture and Conduct Risk Right First Time is a workshop that we're delivering at the BBA. And David, 26th of May, SMR, Are You Taking Reasonable Steps, which is a overview, 1.5 hour overview that you've kindly said that you would deliver to member banks as well, unpacking some of these issues here, but also with some case studies and some examples and questions from the book that you've placed as well. Do you want to just elaborate a bit on what people would be able to get from that?
Sure. I mean, I suspect that it will be heavily based around specific scenarios. So real life case studies designed to flush out some of the more thorny issues that senior managers face on a day-to-day basis, to try and tease out, okay, so how do you deal with this particular dilemma that you're presented with? What's the right approach? What sort of consideration should be going through your mind? How do you prioritise one very important assignment over another? What are you expected to do in the circumstances? So I think as I said, today we've only managed to scratch the surface. The follow-up session, I think we'd go into more granular detail centred around some specific case studies.
Yeah.
And I know that, David, you're the author of a practical guide to implementing the individual accountability regime, which I know is sold like hotcakes. Presumably people can get in touch with you or maybe even buy it on Amazon. I don't know.
Amazon, Sweet and Maxwell, get in touch with our marketing department at McFarlane's. Any of those routes.
And finally, what we decided to do at the BBA, as David has said, is to undertake a survey of how you feel that the SMR regime has impacted on business, impacted also as you as individuals. We're collecting questions and sense checking questions as well with a number of members there, and we'd like to get that out to you. So if you find that in your inbox one day, please look over it. Only take you 2 minutes to complete, and we'll be publishing the results in a forthcoming webinar on that. Thank you very much indeed for that. What we will do is that we will make sure that this on-demand version is available by the end of today. And to you, if you do have any questions, please ping me an email, philip.allen@bba.org.uk, and we will inevitably try and get these questions answered. Thank you very much for your time, and have a good day.